Welcome to Still Unanswered. I'm Mara Ellison. Today, we return to a case that has haunted courts, congressional hearings, and the public imagination for more than 2 decades, the Jeffrey Epstein case. We will walk the timeline, but more importantly, we will keep returning to the same question: what remains unanswered, and why does that matter? Sitting with me is Dr. Caleb Hart, former federal prosecutor and criminal justice scholar. Caleb, thanks for joining.
Thanks, Mara. Glad to be here. It's a heavy topic, but one that needs sober attention.
So, quick ground rules. We will discuss allegations of sexual abuse and trafficking. We will center survivors' accounts and avoid lurid detail. We'll rely on court records, reporting, and official documents where possible. Caleb, before we dive into particulars, give listeners a short, plain English sketch. Who was Jeffrey Epstein, in the contours that matter to this conversation?
Jeffrey Epstein, born 1953, New York. He moved from teaching at elite private schools into finance, set up a firm that presented itself as wealth management for the super-rich. Crucially, the public record does not show a transparent business model. Instead, you have this opaque mix of donations, property transfers, and a circle of powerful people he cultivated. The mystery about the source and scale of his wealth is, in itself, one of the unanswered questions we'll keep circling back to.
Right. People often say billionaire, like it's a settled fact. But when you look for a normal paper trail, you don't find one. That opacity mattered because it bought him access and, arguably, protection.
Exactly. Influence, gifts, hospitality, access to elites, those are the currencies Epstein traded in. Whether that was his business or a cover for something else, we don't fully know.
Let's start where the criminal thread begins, at least in the public sense. Palm Beach, 2005. Caleb, take us into the local investigation. What did police find, and why did it look like the federal system should have gotten involved?
In March 2005, Palm Beach police received a complaint from the mother of a 14-year-old. That complaint triggered an investigation that quickly uncovered multiple similar accounts. Girls recruited from local shopping centers, schools, neighborhoods, a pattern of cash payments, and a system in the house to funnel girls to specific rooms. Detectives described a household system and identified at least 5 victims and dozens of potential witnesses. The evidence was not just scattered rumors. There were interviews, victim statements, financial paper trails in the form of cash payments. That scope, on its face, suggested federal sex trafficking charges were appropriate because there were elements of interstate travel, cross-state activity, and an organized recruiting scheme.
And that is where things get complicated. We hear about state prosecutors, federal prosecutors, the FBI draft indictment, even a 53-page federal draft that some journalists later reported on. But the end result, at least initially, was a deal that many victims and investigators saw as far too light. Walk us through the non-prosecution agreement. What did it do, and why did it create the sense of a cover-up?
In 2007-2008, Epstein's legal team negotiated an NPA with the U.S. Attorney's Office in the Southern District of Florida. The deal allowed Epstein to plead in state court to 2 prostitution-related counts, register as a sex offender, and receive an 18-month jail sentence, typically served with work release, and it effectively ended the federal investigation. Critically, the NPA contained a provision protecting unnamed potential co-conspirators from federal prosecution. Victims later said they were never told about this agreement while it was being negotiated, which led to litigation under the Crime Victims' Rights Act. Legally, prosecutors argued their actions were permissible. Ethically and politically, the deal looks like a raw miscarriage where the scale of alleged conduct didn't match the outcome.
There are a few layers I want us to not lose. 1. Survivors said they were kept in the dark. 2. The federal draft indictment, the FBI activity, the number of potential victims. That suggests federal charges were on the table. 3. Epstein served most of his sentence outside the jail on work release. Does the law explain why prosecutors agreed to this outcome, or do we have to look at power and influence?
Both. Legally, prosecutors have wide discretion. They can enter into agreements if they think it serves justice, preserves witness testimony, or mitigates other risks. But discretion must be accountable. In Epstein's case, the combination of powerful lawyers, negotiations behind closed doors, and the subsequent secrecy around the NPA raises serious questions. The Inspector General and other oversight bodies later criticized aspects of the decision-making, but we still lack a fully transparent public accounting of why the federal avenue was effectively shut down in 2008.
That's a key, still unanswered point. Who benefited from the NPA, and who did it protect? The document shielded unnamed co-conspirators. That's an invitation to suspicion. But suspicion is not prosecution. Tell listeners what the subsequent litigation revealed about victims' legal options and what the court said about their rights.
Survivors sued, arguing prosecutors violated the CVRA by not informing them of the NPA. A federal judge initially said the government violated victims' rights by hiding the deal. But the 11th Circuit later narrowed the statute's scope to exclude pre-indictment negotiations, which shut down a lot of the relief victims sought. So you have an ethical wrong that many agree happened, victims being excluded, but the legal doctrine at the time made it hard to invalidate the agreement. That's another still unanswered element, ethically condemned conduct that remained, technically, within prosecutorial discretion.
The system's rules, as written, allowed a prosecutorial outcome that many believe privileged power over victims. We'll come back to the implications of that for institutional trust. But first, let's pivot to the way Epstein's network mattered. He wasn't operating alone. He had properties, flights, contacts. How did that social capital function as both cover and leverage?
Epstein cultivated relationships with wealthy financiers, politicians, scientists, and celebrities. He hosted salons, donated to institutions, and created an appearance of legitimacy. That social capital did two things. It insulated him because people in power may be reluctant to pursue or publicize allegations against someone with those ties. And it supplied him with the appearance of respectability that can deter questions. The flight logs, the little black book of contacts, donations to universities, all of those created a veil. Again, association isn't guilt, but it does matter for understanding how power and secrecy can interlock.
There's also the Leslie Wexner relationship that kept coming up in reporting. Wexner gave Epstein power of attorney in some cases, and there's that Manhattan townhouse that became central to investigations. The specifics are messy, but the bottom line is there are assets and access that we still don't fully explain.
Yes, Wexner's precise role, what he knew, what he authorized, remains unclear in the public record. Investigative reporting, including documents released later, have suggested deep financial ties. Wexner has said he was a cooperating witness in some matters. But the larger question, how Epstein amassed or maintained wealth and why the financial trail is so opaque, remains unresolved.
Okay, jumping forward now. 2014 to 2018, the Miami Herald series Perversion of Justice reignites public interest. Survivors speak out. Civil suits begin to peel back secrecy. Then, in July 2019, Epstein is arrested at Teterboro and charged in the Southern District of New York with federal sex trafficking crimes. That felt like a turning point. Caleb, why did SDNY's 2019 indictment feel different?
Several reasons. First, the jurisdiction was different. SDNY is often willing to take on high-profile financial and criminal cases with more independence. Second, the substantive charges were federal sex trafficking counts, covering alleged conduct in the early 2000s involving multiple victims and travel. Third, the public pressure had mounted. Survivors, investigative reporters, and civil litigation had forced many facts into the open. The combination made it look like federal accountability was finally possible.
And yet, August 10th, 2019, Epstein is found dead in his cell at the Metropolitan Correctional Center. The death, the manner, the sequence exposed massive procedural failures. We have to handle this carefully. We will present facts, highlight discrepancies, and explain why reasonable suspicion persists, but we won't traffic in wild speculation. Caleb, outline the known facts about his death and the immediate procedural breakdowns.
On August 10, Epstein was found unresponsive in his cell and later pronounced dead. The New York City medical examiner ruled the death suicide by hanging. But there were cascading failures at MCC. Epstein had been on suicide watch after an earlier incident, but was reportedly taken off suicide watch. He was placed in a special housing unit with required checks that were not performed. 2 correctional officers allegedly fell asleep or failed to perform required checks and then falsified logs. Some surveillance cameras reportedly had footage gaps or malfunctioned. Those failures are documented in DOJ and Inspector General reviews and in criminal charges against the 2 officers for record falsification. The combination of a high-profile detainee, documented failures, and disputed autopsy details created a credibility crisis.
And then there's forensic disagreement. Dr. Michael Baden, privately hired by Epstein's family, publicly said some findings were more consistent with homicidal strangulation, citing neck fractures, involvement of the hyoid bone. The medical examiner found suicide. A panel later majority supported suicide, but with some dissent. So we have experts in disagreement. What does that tell us about the strength of the case for foul play versus negligence?
It tells us 2 things. First, a forensic determination can be complex. Neck fractures can occur in suicidal hangings, though some pathologists find them more common in manual strangulation. Second, in court of public opinion terms, the combination of procedural failures and forensic ambiguity fuels suspicion. Legally, to claim homicide, you'd need more than ambiguous autopsy findings. You would need clear evidence of another party's involvement. What is unambiguous is the stunning incompetence and perhaps willful negligence in the custody protocols. Whether negligence alone explains it, or whether there's reason to open an entirely new homicide inquiry, remains a debated question.
Listeners, the unanswered question here isn't just, was he murdered? It's also, how did a detainee with documented suicide risk receive such abjectly poor care? That, too, speaks to institutional failure. Let's move to Ghislaine Maxwell. She's the one major figure convicted in connection to Epstein's sex trafficking operation. Caleb, explain how her prosecution differed from earlier failures and why her conviction matters and yet still leaves gaps.
Maxwell was arrested in July 2020 and tried in late 2021. The prosecution presented her as a recruiter and facilitator, someone who groomed young girls and introduced them to Epstein, and sometimes participated. The trial centered on 4 accusers whose testimony described grooming, transportation to properties, and Maxwell's role. The defense painted her as a scapegoat and attacked credibility. The jury convicted on multiple counts. She was sentenced to 20 years. Her conviction matters because it's a rare instance of criminal accountability for a high-level enabler. But it also leaves gaps. Prosecutions require proof beyond a reasonable doubt. Many alleged co-conspirators were not charged. Maxwell's conviction answers some questions. It validates survivors' accounts against one central facilitator. But it does not close the larger network or name others who may have been involved.
And we should say plainly, Maxwell appealed, argued the Florida NPA should apply, and lost at the Second Circuit. The Supreme Court later declined to hear her challenge. So criminally, Maxwell is the single major figure punished, while many other names remain subject to suspicion, civil claims, and redactions. Which brings us to the Epstein files and the transparency push. In 2024-2026, more documents are released, sometimes unredacted. That created both breakthroughs and missteps.
Right. Unsealing documents can illuminate the scope of an investigation and reveal previously redacted leads, but it can also spread raw investigatory materials outside proper context. The 2026 episode, when congressmen reviewed unredacted FBI files and named 6 men, highlights this double edge. Some individuals named were prominent and raised legitimate questions. Others were misidentified or were simply part of investigative procedures like photo arrays. The Justice Department later clarified that 4 men in a photo array had no ties to Epstein. So transparency can correct injustice, but it can also mistakenly taint innocence if released without context or care.
That tension, transparency versus fairness, is crucial. The public wants the truth, and survivors want accountability. But unchecked releases can harm lives and cloud what we actually know. Caleb, the push for Congress to subpoena or force testimony from figures like Peter Mandelson, or for public explanations from people like Les Wexner and Ehud Barak, what can Congress realistically accomplish here, given statutes of limitations and the passage of time?
Congress can compel testimony, issue subpoenas, require document production, and hold public hearings that pressure agencies to explain their conduct. It can also legislate transparency measures, such as the proposed Epstein Files Transparency Act. But Congress cannot resurrect dead charges where statutes of limitations have run, or create evidence that doesn't exist. What congressional action is best suited for is oversight, probing prosecutorial decisions, requesting unredacted documents from the DOJ, and exposing systemic failures. That creates political pressure, which in turn may motivate prosecutors to reopen avenues, but it's not a guaranteed route to new criminal prosecutions against high-profile individuals.
Let's be blunt. Many listeners want names. Who else did it? The files and flight logs make people suspicious. But being on a flight log or in a contact book is not proof of sexual abuse. Lay out for listeners the difference between association and criminality and why investigators proceed cautiously.
Association is evidence of social contact. You can be on a flight with someone for business reasons, a social event, or a single ride. Criminality requires a link between that association and illicit conduct, witness testimony, corroborated patterns, documents showing intent, or transactional sex with minors, or corroborative physical evidence. Investigators must satisfy burdens of proof. Allegations against powerful people are hard to prove after the fact because memories fade, documents are sealed, and victims may have settled in civil suits. That's why some figures become subject to public suspicion but escape criminal indictment. Not necessarily because they're innocent, but because the evidentiary threshold for prosecution is high.
And sometimes the opposite happens. Public naming without context damages innocent people. We saw that with the 4 men mistaken for co-conspirators in the photo array. So transparency has to be paired with responsible, contextual release. I want to bring survivors back into the center here. Caleb, civil suits against Epstein's estate ultimately forced disclosures and set up a victims' compensation fund. How should listeners understand the role of civil law in seeking accountability where criminal law can fail?
Civil suits serve different functions. They can produce discovery, depositions, documents, depositions under oath, and financial disclosures that are hard to get in a criminal investigation. They can also result in monetary compensation and public validation of victims' accounts. But civil cases often end in confidential settlements that keep details hidden. Civil findings aren't the same as criminal convictions. They require a lower burden of proof. For victims, civil suits can be a pragmatic route to both redress and fact-finding. But for public accountability, we often want public, criminal adjudications that name perpetrators and carry a stigma and punishment beyond money.
Which brings us to the broader institutional question. What does the Epstein case reveal about prosecutorial discretion, prison administration, and institutional bias when the accused is powerful? Caleb, you've been a prosecutor. Where did the system fail, and where did it hold up?
It failed in several places. The 2008 NPA raises questions about prosecutorial choices and transparency. The MCC failures around his death show prison custody breakdowns and possible corruption or negligence. The limited criminal accountability for others suggests either evidentiary gaps or prosecutorial caution. Where it held up, Maxwell's prosecution and conviction shows that with sufficient evidence, a responsible prosecutor can secure accountability even years later. The mixed picture is what fuels public rage. The system can work, but too often it doesn't scale, particularly when wealth and influence are involved.
Let's talk about the autopsy again for a minute. Some listeners have seen internet claims that forensic disagreement means definite foul play. Others say the ME's determination is definitive. Put that debate in perspective. What do courts or investigators need to move from suspicion to prosecution in a death case like this?
In a homicide investigation, you need evidence of another person's causative conduct. Physical evidence, credible witness testimony, means, motive, opportunity, surveillance footage, communication intercepts, etc. Forensic opinion is part of that mosaic. Disagreement among pathologists raises a question. It doesn't resolve it. To reopen a homicide investigation credibly, you'd need new, tangible evidence beyond differing interpretations of the autopsy. What we do know is that the custody failures and documentation irregularities justify intense oversight and institutional reform, even if they don't conclusively prove homicide.
Listeners, that's important. Unanswered doesn't equal conspiracy. It means there are holes in official narratives that deserve honest scrutiny. I want to pause and give survivors voice. We've named Annie Farmer and Virginia Giuffra. We won't recount explicit personal detail, but can you summarize what their public testimonies tell us about how Epstein and Maxwell operated?
Survivors' testimonies paint a consistent picture. Recruitment through promises of modeling, education, or financial help, grooming through flattery, gifts, and normalization, and an operational method where young women were encouraged to bring others in, a pyramid or supply structure. Many described being transported to multiple properties, being introduced to powerful acquaintances of Epstein's, and feeling trapped by shame and reliance on the money they were paid. Those narratives humanize the crime and demonstrate the pattern prosecutors relied on in Maxwell's trial. They underscore how vulnerability and power disparities were weaponized.
And that human dimension is the moral engine of this episode. These are people whose lives were damaged. The public focus on famous names sometimes overshadows the survivors themselves. We must always come back to them. Now, the so-called Epstein network included politicians, business people, scientists. Some had legitimate, innocent contact. Others, we still don't know. How should investigative journalists and prosecutors proceed when powerful people are implicated by association?
Carefully. Investigative journalists should verify through multiple sources, obtain documents, and avoid insinuation from mere proximity. Prosecutors must follow evidence, seek corroboration, and assess witness credibility. Both should be mindful of false positives, the risk of wrongly implicating innocents, while also resisting pressure to close cases prematurely out of deference to the powerful. Transparency in methods, thorough vetting of names before public assertion, and clear delineation between allegation and proven fact are essential.
We also need a word about intelligence rumors. Over the years, there have been persistent claims that Epstein worked for some country's intelligence apparatus. You yourself warned of rumor pitfalls. What's the standard for evaluating those assertions?
Extraordinary claims require extraordinary evidence. Intelligence ties are plausible as rumors because of Epstein's access and possible leverage, but publicly released records do not conclusively show he was an intelligence asset. Investigators should examine travel records, communications, payments, and any official documentation. Until such evidence is public and corroborated, treating the claim as proven is irresponsible. Distinguishing plausible hypothesis from established fact is part of our job.
Let's move, Caleb, to concrete, still unanswered questions, the ones we'll end the episode with and return to throughout. I'll list them, and you respond briefly to each with what we know and what's missing. First, how did Epstein get his money and power?
What we know, Epstein ran a financial firm, had wealthy clients, and received assets, notably from Leslie Wexner. What's missing, a transparent accounting of his business dealings, full documentation of his income streams, and who, if anyone, provided financial cover or fronting. The absence of a clear paper trail is a major unanswered piece.
Second, why was the 2008 NPA so generous, and who exactly did it protect?
What we know, the NPA prevented federal prosecution and referenced unnamed co-conspirators. What's missing? A full public explanation of prosecutorial reasoning, the identities the agreement shielded, and whether the decision was influenced by political or social pressure. The limited oversight of prosecutorial discretion left many questions unresolved.
Third, why did federal authorities wait until 2019 to arrest Epstein again, given media reporting and civil suits earlier?
What we know, renewed reporting and civil cases pushed facts into the open. New prosecutors in SDNY pursued charges. What's missing? A clear public accounting from prior federal offices explaining why they didn't pursue further charges earlier, whether it was lack of evidence, strategic choices, or failures in investigative follow-through.
Fourth, what truly happened in his cell on August 10, 2019?
What we know, he was found dead. ME ruled suicide. There were custody failures and differing forensic opinions. What's missing? Conclusive, new evidence proving homicide, or fully exculpatory proof that procedural incompetence alone explains everything.
Fifth, why have so few others been held criminally accountable?
What we know, Maxwell was prosecuted and convicted. Many civil suits resulted in settlements. What's missing? Prosecutable evidence against other alleged co-conspirators or clear prosecutorial will to pursue them, considering statutes of limitations, witness credibility issues, and evidentiary hurdles.
Sixth, how do you balance transparency and fairness when releasing the Epstein files?
What we know. Unredacted releases exposed potential leads but also misidentified innocents. What's missing? protocols for redaction that preserve investigative integrity while preventing wrongful implications, and perhaps independent review mechanisms to vet disclosures before public release.
And finally, what does the Epstein case reveal about institutions? Do we have systems capable of confronting crimes when powerful people are involved?
What we know, the system can work. Maxwell's conviction shows that. But the system also failed. The 2008 NPA, the custodial breakdown, and the slow-moving accountability for others. What's missing? Structural reforms to ensure transparency in prosecutorial decisions, stronger oversight in correctional custody for high-risk detainees, and mechanisms that protect victims' rights early in investigations.
Before we close, I want to address the emotional and moral context. This case triggers anger, disbelief, and grief. Survivors deserve recognition, institutions deserve scrutiny, and the public deserves factual clarity. Caleb, what reforms would you prioritize that would actually change outcomes in future cases involving powerful suspects?
First, stronger statutory protections for victims' rights that apply at all stages, including pre-indictment. That would prevent secretive deals from excluding victims. Second, more robust oversight of prosecutorial plea-making, perhaps greater transparency or independent review when deals involve high-profile defendants. Third, reforms in detention, clear accountability for guard conduct, improved monitoring technology, and independent audits after critical incidents. Fourth, improved processes for releasing investigatory documents to balance transparency and privacy, maybe a neutral third-party review before wholesale public release.
Good. Concrete steps. As we wrap, I want to be clear about what this episode is not. It's not an attempt to brand every name in the Epstein orbit as guilty. It's a call to keep asking hard questions where official explanations fall short. And it is a reminder that behind every document and flight log, there are survivors who deserve justice. Caleb, final thought. If you had to give one sentence to listeners about why this case matters for democracy and the rule of law, what would it be?
It matters because how a society treats the vulnerable and how it holds the powerful accountable are the clearest measures of whether the rule of law is real or merely a promise. And in the Epstein case, we still have too many unanswered promises.
Powerful. Thank you, Caleb. Listeners, we'll include a show notes page with primary sources, the Miami Herald series, DOJ filings, the Maxwell case docket, and important reporting from The Guardian, AP, and others. If you want to read more, and you should, those links will be there. One small but important final note. If this episode raises painful memories for you, please reach out for help. We'll include resources for survivors in the notes. Thank you for listening. I'm Mara Ellison. This is Still Unanswered. We'll be back with another episode that digs into one more case where institutions failed to answer the public's questions.
Thank you for having me, Mara. And thank you to listeners for sticking with such a difficult subject.
Good night.